25 CR 947 is called the state of Texas versus Jeremy.
This courtroom is about to become a pressure cooker. What starts as a routine arraignment quickly turns into a brutal reality check for a repeat offender who has made one thing painfully clear. He doesn't respect the law, and he doesn't fear the consequences. The defendant in this first case, Jeremy Coleman, isn't new to evading police. In fact, this is his fourth time facing that exact charge. And today, the judge isn't interested in excuses, he's interested in patterns. As you listen, pay close attention to how quickly this case escalates from a misdemeanor to something far more serious. Prior convictions matter, attitude matters, remorse matters, and when the defendant openly admits he doesn't like police and by extension, doesn't respect the law, you can feel the tone of the courtroom shift. This hearing isn't just about what happened on one night in June 2025. It's about whether the justice system has finally reached the end of its patience.
Evading arrest or detention. Paragraph 2 goes on to allege that you have 3 prior convictions, 2 in October. Well, sorry. The first one, there's 3 differences. One, October 29, 2004, out of this criminal district court of Jefferson County, you were convicted of evading arrest or detention with the use of a vehicle. January 4th, 2010, in County Court of Law 3 of Jefferson County, Texas, you were convicted of evading detention. And October 26, 2023, County Court of Law 3 of Jefferson County, Texas, you were convicted of the offense of evading arrest or detention. What is it about that you have a problem with? You know, stopping the police or trying to stop you. Why do you flee? Yeah. This is the 4th time I know about you pulled a stunt like that. Why would you do that?
I don't know, sir. No reason.
Well,
Did I tell you anything?
Yeah, but everybody's got a reason, and nobody knows better than you about
like
you.
Police. I don't like police, sir.
How about the law? You don't like the law either?
This is the moment everything goes sideways for the defense. When the defendant openly tells the judge he doesn't like police and can't even offer a reason for repeatedly fleeing, confirms exactly what the court is already thinking. Judges aren't just evaluating charges. They're evaluating credibility, accountability, and whether a defendant can be trusted to follow the law going forward. Legally, this is huge. Those prior convictions don't just sit in the background, they enhance the charge. What might have stayed a misdemeanor now risks becoming a felony with real prison time. The judge even spells it out. With multiple prior state jail convictions, this could rise to a 3rd-degree felony carrying up to 10 years. And instead of showing remorse, the defendant appears flippant, almost indifferent. That's why the judge makes a critical call here. No plea deal, no shortcuts. This case is headed straight to trial, and now the jury will decide his fate.
He doesn't care. He doesn't like police, doesn't like follow the law. And why? I mean, first of all, somebody's supposed to show remorse and doesn't show it at all, doesn't care. And let's let the law work its way through. Okay. So set it for trial. That is all. Tom, you ready? On something?
Mike, have you signed the paperwork?
If you can sign, I don't know if he's gonna get it all good.
He's over.
What do we have here?
My knee is metal. And
We have Heather Boudreaux.
my hands.
Is it one case? Yes, sir. Stop.
I'm sorry.
I'm speaking. Let's go. We got things to do here. You're Heather Boudreaux, right?
Yes, sir.
All right, there's a motion to revoke probation that has been filed in 24 CR 560. And this was filed on September 18th. And so it's going on 3 months, and we need to move this thing one way or the other. You are sentenced to 10 years imprisonment, probated for 10 years for unlawful possession of a firearm by a felon. And It is alleged you committed the offense of assault on a public servant on or about August 9th, 2025 in Hardin County. Committed the offense of resisting arrest or search on or about August 9th, 2025 in Hardin County. Committed the offense of assault causing bodily injury, family violence on or about August 9th, 2025 in Hardin County. It must be out of the same episode. And then failed to pay court assessed fees, and you owe $400 in arrears in violation of a condition of your probation. You were sentenced to 10 years in prison, and that was probated for 10 years. Go ahead.
Judge, we're asking that the court grant her a reasonable bond, so that she can go take care of the Hardin County cases. All the state's motion is based primarily on 3 cases, allegations out of Hardin County that I'm unable to affect in any way.
Why?
Because I don't represent her. And so it's going to be, I'm dependent upon what Hardin County does, what I don't have.
No, you're not. You've got to earn a motion to revoke probation, and it's got its own circumstances here, and it's a preponderance of the evidence standard, so it's kind of a different thing. But we don't have to.
This second case highlights something many viewers misunderstand about probation. Once you're on it, the court that granted it has full authority over you. Heather Budrow was originally sentenced to 10 years in prison, but that sentence was probated. That was her second chance. Now, with new allegations including assault on a public servant, resisting arrest, family violence, and unpaid fees, that second chance is hanging by a thread. The defense argues that other counties still have pending cases, but the judge shuts that down immediately. Legally, he's absolutely right. A motion to revoke probation doesn't require waiting on other jurisdictions. The standard of proof is lower, the court has discretion, and the priority is public safety. This judge makes it clear, efficiency matters, accountability matters, and this court will not be held hostage by delays elsewhere. This is probation court, and probation comes with consequences.
Plus efficiency and trying to see whatever Hardin
It's
County.
judicially efficient for me. That's what's important for Jefferson County and the people I speak with, and I know how other counties are. And we dispose of most cases of anyone in Region 2. We all know that. Everybody works hard, and they're all chasing us. So we're going to continue to lead the pack on dispositions and hard work and moving these cases. So it's in our domain, and she's on regular probation right now. So that is the court's looking at these new offenses, and which are serious, and the court is going to, in all due respect, deny a bond, which I can do since she's on regular probation, but I promise this will be done in 4 weeks, one way or the other. Y'all decide if y'all can do it by agreement. If not, I'll make the decision. And the state can be ready in 4 weeks. Thank you. That's what we'll do. Thank you.
By the end of this hearing, the message from the bench is unmistakable. In the first case, Jeremy Coleman's repeated refusal to comply with the law, combined with his own words, sends him straight toward a jury trial, where his past will follow him into the courtroom. In the second case, Heather Budrow's probation is under serious threat as the judge denies bond and fast-tracks a revocation hearing, citing the severity of new offenses and the court's authority to act swiftly. These cases highlight a hard truth. Probation and leniency are privileges, not guarantees. Courts can forgive mistakes, but they won't tolerate patterns of defiance. Now I want to hear from you. Do you think the judge handled these cases fairly, or was the response overdue? If you found this courtroom breakdown as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.